says from Citizen, the fiction of the facts assumes innocence, ignorance, lack of intention, misdirection, the necessary conditions of a certain time and place. A certain time and place. And this question of the location and time for thinking about certain things is key to this poem. And I'll read just one last snippet from that. He said, I don't know what the water wanted. It wanted to show you no one would come. He said, I don't know what the water wanted, as if then and now were not the same moment. As if then and now were not the same moment. So how a field might, this is me now, just a few opening remarks, how a field might talk can seem a bloodless enough topic when what we are or are not talking about is race. And yet those of us who've experienced the challenges of addressing racial controversies, even within our own institutions, will immediately recognize the force and importance of the fundamental issue we're here to address today and tomorrow. Inadequate or harmful language provokes outrage and moral certainty on the meaning of terms in some quarters, silence and inhibition on others. These are characteristic extremes when the topic of race is raised. Can things be different? Where does ongoing scholarship help us? Where might it be pushed forward by current formulations? How might we talk about race when it is urgent to do so? I'm extraordinarily grateful that the question has been posed by the organizers of this event. For everyone in an academic field dealing with language, the question is vital. For students of the 19th century, when so many of the most injurious concepts arose or were consolidated, when race itself was evoked to determine so much, it's a topic that must be addressed. How to do so in a sound, probing, responsible way is our challenge. Today, we see on all hands a call for what is sometimes described as a new reckoning on race, as well as an almost immediate backlash to that project. And then many scholars of the 19th century have been engaged with these fundamental topics for years. But it's not clear that intellectual horizons have always met when empire, colonialization, the enslavement and displacement of peoples have been addressed in specialized areas or within national traditions. Field-specific or nation-specific concerns can constrain conversations that might be of value elsewhere, or missed conversations that would enrich them. More than that, it is hard to avoid the feeling that the relationship between the felt urgencies of the moment and the study of the past must be reflected upon with more care, engaged more closely. What appear to be generational divides in thinking about language and responsibility in relation to past and present injustices have also made themselves evident of late. But is there more to be said about ongoing scholarship and current concerns than to identify limits and disjunctions? And then, if the reckoning of which people speak has taught us anything, it is that different subjects, scholars or otherwise, live the experience of modern concepts of race in distinct ways, that general formulations will always be inadequate to match the lives shaped and distorted by racist practices. I trust that the event we're having today and tomorrow will honor the provisional, aspirational elements of its title. How might Victorianists talk about race? Over the next 2 days, we'll hear a number of distinct answers or simply examples of how this might be done. My sincere hope and expectation is that some of the answers we hear will surprise us or push us away from what we expect or know. As my own inadequate remarks will have made clear, I myself am here to learn. I'm extraordinarily grateful to the organizers and everyone else who has made this event possible, and to all of you for not being silent, but for helping us work through this question. I look forward to your willingness to speak. Again, I'll just close with where I opened with these lines from Claudia Rankine. He said, I don't know what the water wanted. It wanted to show you no one would come. He said, I don't know what the water wanted, as if then and now were not the same moment. All right, so it's an invitation to think about what the matching of temporal horizons might do for our discussions of race today. So I'd like to, that's it for my opening remarks. Again, I can only reiterate my great gratitude to Lauren and Sukanya for their thoughtful and imaginative work in putting this event together. And I'd like to get out of the way as soon as possible to let us learn from others. So let me, I think everyone's here from the first panel. So I will start by introducing the moderator, Elizabeth Chang. If you can make yourself visible, Catherine as well. Elizabeth Chang is professor of English at the University of Missouri, where her teaching and research centers on the literature and culture of the British Empire. She is the author of novel Cultivations, Plants in Global British Literature, which came out in 2019, as well as Britain's Chinese Eye, Literature, Empire, and Aesthetics in the 19th Century, which it's an extraordinary book that carries out some very difficult projects, and has also published on, among other topics, Chinese plants in British gardens, British accounts of Chinese foot binding, and Victorian science fiction. Her current project concerns British travel writing from China and environmental sovereignty. So I'll turn it over to her.
Hi, and welcome to everyone. I'm so pleased and just honored to be a part of this group. I want to be very quick in what I'm doing, so we have plenty of time for all the presentations and your questions. So as you know, we'll hear two presentations. I'm going to introduce both speakers quickly right now, and then during the talk, or of course after the talks conclude, please use the Q&A function to put your questions in, and I will relay those to the panelists, and I hope we'll be able to have a rich and vibrant discussion. So I'm really looking forward to this. So without further ado, well, let me just directly especially thank Lauren and Sukanya for inviting me to be a part of this, and more importantly, for creating this opportunity and space for this conversation. So without further ado, let me introduce the two panelists. Our first speaker will be Catherine Hall. She is Emerita Professor of History and Chair of the Center for the Study of Legacies of British Slavery at University College London. Her recent work has focused on the relation between Britain and its empire, civilizing subjects from 2002, Macaulay and Son from 2012, and Legacies of British Slave Ownership from 2014. Between 2009 and 2015, she was the principal investigator on the ESRC-AHRC project Legacies of British Slave Ownership, which seeks to put slavery back into British history. Her new book will be Making Racial Capitalism, Edward Long's History of Jamaica, and the title of her talk today is Edward Long, The History of Jamaica and the Figure of the African. Our second speaker will be Sarah Winter. She is Professor of English and Comparative Literary and Cultural Studies at the University of Connecticut Stars and co-director of the research program on humanitarianism at the Yukon Human Rights Institute, an interdisciplinary scholar of 19th century British literature, human rights, and the history of law and the modern disciplines. She has published most recently a co-edited collection with Elaine Hadley and Audrey Jeff, From Political Economy to Economics Through 19th Century Literature, Reclaiming the Social, that came out from Palgrave in 2019. Her talk is part of her current book project, which focuses on citizen activists' strategic use of common law procedures of habeas corpus to contest slavery, promote decolonization struggles, and assist detained refugees between the 1760s and 2017. The project also identifies the distinctive human rights narratives that have emerged from this activism across literary texts, political discourse, and popular culture. The title of her talk for today is The Jamaican Magistrate and the Canadian Refugee, Race, Jurisdiction, and Empire in the 1860s. So without further ado, I will turn the conversation over to Professor Hall.
Hello, everybody, and thank you for that introduction. And let me first of all thank Lauren Goodlad and Sukanya Banerjee for the invitation to contribute to this discussion on how Victorianists might talk about race. When they asked me, I said, but I haven't been working on the 19th century for some time. I've retreated to the 18th century and am firmly embedded there with Edward Long and his History of Jamaica. They encouraged me to be here today nevertheless, so here I am. And I'm speaking from the UK, where the politics of race of then and now are somewhat different from the US. In the 1990s and the first decade of the 21st century, I worked on late 18th and early 19th century racial thinking in the context of post-colonial questions. Civilizing Subjects explored the significance of imperial identifications to the constitution of white English identities. What did the missionary and abolitionist publics know about Jamaica, and how did they think about racial difference? Then my focus shifted to the place of history writing in formations of national and racialized identities. And in Macaulay and Son, I tracked the conditions of production of his History of England, an exclusively white island story. In the wake of 2007 and the national conversation engendered in the UK by the bicentenary of the abolition of the slave trade, Nick Draper, Keith McClelland and I established the Legacies of British Slave Ownership project. We had two major inspirations: the work of the new imperial historians, which insisted on the relation between metropole and colony as central to British history, and Eric Williams's Capitalism and Slavery. Williams argued that slave wealth was important to the economic, social, and political fabric of 18th century Britain and made an important contribution to the Industrial Revolution. We used the compensation paid to slave owners in 1834 as our lens, asking who were the men and women who benefited from the compensation, what did they do with the money, and what influence did they have? We focused on unpicking the story that Britain liked to tell itself of the gift of abolition and emancipation, revealing the scale of the wealth amassed by British slave owners and exploring the part they played as capitalists, politicians, cultural connoisseurs, and writers in the development of modern Britain. West Indians returned to the metropole with ideas and practices of racial difference and hierarchy, which became embedded in British culture, politics, and institutions. A second phase of the work analysed the significance of slave ownership in the British West Indian colonies between 1763 and 1833, addressing the same questions, and we have continued to add material to our database from that research. Over 2.25 million people have now visited our website, and this work has shifted public understanding of slavery and emancipation. My recent research on slave owners has focused on Edward Long and his family. I'd known about Long for decades, as does everyone interested in the history of Jamaica. He published his 3-volume History of Jamaica in 1774 and was recognized as the authority on the island, cited by friends and enemies alike. The work has remained in print ever since. Long aimed to tell a story of the growth from an infant colony to a settled society. Those interested in the intellectual history of race know of him, for it was one of the first texts in English to theorize racial difference. For Jamaicans, it's an infamous text, the most influential account of a colonial racial system, which was reconfigured after emancipation, but whose traces remain all too clearly on the island. For Peter Fryer, whose staying power was one of the first 20th century histories of Black Britons, Long was the father of English racism. For Simon Gikandi, his production of a terrifying Black spectre constituted a new economy of debate in which the debasement of the Black was the signal of a particular way of speaking about modern identity. Long's attempted theorization of racial difference rested on two arguments that contradicted each other. Firstly, that African inferiority was essential and natural, that inequality was ordained by Providence, embodied in blood, skin, hair, bone, and brain. Black people were born to serve whites. Secondly, he argued that those Africans brought as captives to Jamaica were savage and barbaric, but that plantation slavery was capable of partially civilizing them. Creoles born on the island could become useful laborers for a settled society. He never confronted this contradiction between what was natural and what was cultural. both aspects of his racial thinking, natural difference and cultural difference, have remained central to the two registers of racisms with which we are so familiar, configured differently as they are at different times and in different places. Race, as Stuart Hall argued, functions as a sliding signifier. A discursive conception of the politics of race means that every cultural tradition is a reworking, a remaking of identities that is specific to time, place, and circumstance, not a persistent, unchanging preservation and replication across time, space, and history of some essential, originary, naturalized same. The historical political work that culture does is this reconstruction, and this is the work that Edward Long did in his history. I'd always read bits of the history, never the whole. The more I read, the more I realized that Long was providing me with an account of the whole system of the West India trade, the plantation economy, the state, and racialized identities, what we might now call the workings of racial capitalism in the mid-18th century. Racial capitalism has become a much utilized term in the period since the financial crisis. Faced with the realities of the fragility of capitalism in its neoliberal form, there has been a revived interest in its history and how it intersects with racialized formations. Racial capitalism is not one thing. There are many different phases of the sets of economic, political, cultural, and spatial relations which together can constitute a system of racial capitalism, and we need to understand them in their historical specificity. Neither capitalism nor racism are stable entities. They shift and change and adapt. It's the articulation between race and capitalism that matters. What were the specific historical conditions in which a particular mode of economic production with different types of capital and different labor practices operating across metropolitan and colonial contexts was articulated with the state and with racialized ideologies in such a way as to function as a system, albeit always with conflict and contradiction. My work on Long has become an investigation through the writings of a slave owner of the system of racial capitalism as it operated in the mid-18th century Atlantic. Edward Long was born in 1734, the third son of a gentry family whose wealth had been derived over 3 generations from the labor of the enslaved on the plantations in Jamaica, which they had owned since the 1650s. His great-grandfather, Samuel, was one of the founding fathers of the colony. Edward was born and educated in England, but the unexpected death of his father, who was in Jamaica in 1757, left him with a meager inheritance. He was advised by his uncle Beeston to go to Jamaica, a place to make a fortune. Uncle Beeston was the head of the West India Merchant House in London, in Leadenhall Street, called Drake and Long, one of the major West India houses. At the age of 23, Edward Long borrowed capital and established himself as a planter, buying one of the family plantations, Lucky Valley, from his older brother, Robert. He set about improving the estate, in the language of the time, determined to make enough money to return to the mother country. Within months of his arrival, he'd married Mary Ballard Beckford, the daughter of another slave-owning family, thus acquiring more property. During his 11 years in Jamaica, he bought enslaved people and land, rebuilt the works at Lucky Valley, and managed to increase the yield of sugar and rum very substantially. In 1760, the year after his arrival in Jamaica, the major rebellion, Taki's Rebellion, took place, the most important uprising of enslaved people in the Atlantic world in the 18th century, prior to Haiti. It made him fully aware of the dangers inherent in this slave society with its massive demographic imbalance of at least 10-1. Elected as a member of the House of Assembly, the representative body of propertied white men, he took an active part in colonial politics, asserting the rights of freeborn Englishmen to their legal and political privileges and challenging metropolitan power. By 1769, he had accumulated enough capital to return to England, expecting to live the life of a well-to-do West Indian, thanks to his Jamaican property, both in land and people, and the ever-expanding demand for King sugar. On his return, he found that much had changed. When he had left, there were few voices raised against slavery. By the time he returned, the question as to whether slavery was legal in England, the celebrated land of liberty, had become a matter of public concern. The slave trade had been legalized, but what about slavery? The case of James Somerset put this to the test. Somerset had been brought to England by the man who claimed ownership of him, James Stuart, but had managed to escape. He was subsequently kidnapped onto a ship for passage to the Caribbean and re-enslavement. Lord Mansfield, the Lord Chief Justice, freed Somerset in 1772, declaring slavery to be repugnant at home. He demarcated between England, a place that did not permit the kidnapping of Africans in order to re-enslave them, and the colonies, where slavery was legitimate. The West Indians, as they were known, were enraged. This judgment challenged their legal right as freeborn Englishmen to hold what they believed was their property. Long was already writing a history of Jamaica. He now realized it must actively defend slavery and convince his metropolitan audience that slavery was essential to British wealth and power. The Somerset trial marked an iconic moment, a moment of rupture in metropolitan understandings of racial difference. Thinking about slavery as in some respects un-English had broken through an established common sense. This heralded a new conjuncture when anti-slavery voices were no longer marginalized, but moving into the center ground of politics and culture. The protracted struggle that ensued only concluded more than half a century later with the abolition of slavery in 1834. Faced with this challenge, Long's history was a defense of racial inequality and difference, an exposition of the benefits of Jamaica to Britain, of the workings of the plantation economy, its political and legal codes, the island's products and inhabitants, both white with a capital W, as he wrote it, and Negro with a capital N. Let me just very briefly and schematically focus on sugar. Sugar-based plantation slavery was organized within a mercantilist framework and navigation acts that privileged the metropole and subordinated the interests of the colony. Jamaica was there to enrich the mother country. The island produced an export crop, sugar, within a system of imperial preferences. The mid-18th century system of West India trade centered on mercantile capital, enslaved Africans, sugar, and rum. It was a complex and hybrid system, transformative of both Britain, Africa, and the Caribbean. It marked a particular phase in the organization of racial capitalism, when goods were exchanged for people, cane was transformed into sugar and rum. The circuit operated in its simplest form from England to West Africa, the Atlantic to the Caribbean, and back to Britain, utilizing different regimes of exploitation. Captives were violently seized in West Africa with no payment. They were sold on the coast by African traders to Europeans, financed with British capital. Men, women, and children were priced and became human property. White waged sailors manned the ships. Once in Jamaica, Africans were bought by factors, renamed as slaves and Negroes with a new price, and sold to planters. They were human capital, the most valuable asset of the plantations where they lived and died. The sugar and rum they produced were shipped back to the metropole by white waged labor. White men manned the docks, the warehouses, the counting houses, and the refineries where the molasses were processed. This hybrid system of exploitation of enslaved and waged labor depended on imperial protection and the circuit of credit in the form of bills of exchange. Promissory notes crisscrossed the Atlantic and allowed credit to flow, debts to mushroom, capital to accumulate, particularly in the hands of the merchants. There was no abstract economic logic operating only according to the rules of the market. Each moment in the circuit of capital, production, reproduction, distribution, and consumption was embedded legally and politically in racialized, gendered, and class practices. At the heart of this system were the plantations and the enslaved. By the early 18th century, large-scale planters, such as the Long family, had monopolized much of the land in Jamaica to grow cane. They depended on metropolitan merchants for the capital to buy land and labor, build the mills, boiling houses, and distilleries that were essential for these factories in the field, as Sidney Mintz called them. They paid with rum and sugar. By the time Edward Long left Jamaica in 1768, there were 296 enslaved people on Lucky Valley, producing on average 300 hogsheads of sugar and 150 puncheons of rum, establishing an excellent income for him and his family. Enslaved men and women were organized in gangs to maximize labor efficiency and supervised by black drivers and a number of white artisans and bookkeepers. A clear hierarchy of labor was both gendered and racialized. The majority of field work was done by women in the first gang, responsible for the heavy work of hoeing and planting, cutting the cane and delivering to the mill. The second gang comprised the older women and weak men who took on less heavy tasks, while the third gang of children and the old weeded, picked grass, and collected dung. The fittest men were the skilled artisans, the millers, boilers, coopers, carpenters, wheelwrights, and stockmen. The most trusted men served as drivers, enforcing discipline with the whip under the eye of the white overseer. In the mid-18th century, the enslaved population was not reproducing itself, and planters such as Edward Long relied on buying new captives to maintain their labor force. Violence and coercion were systemic, the power of the slave owner backed up by that of the colonial state. Jamaica was a garrison state, a slave society in a state of exception. Colonists were fearful of external enemies, for France and Spain were dangerously close and the island offered rich prizes. But it was the enslaved who had to be contained. Resistance of many kinds was endemic, both individual, from runaways to sickness to the use of abortion, and collective on plantations across parishes and beyond. Slave codes, a militia, resident regulars, and naval support were all essential to the slave owners, as was maroon assistance guaranteed by the Treaty of 1739, vital to the effort to suppress the rebellion of 1760. While slavery was defined as black, white colonists insisted on their rights as property owners to consent to their government and make their own local laws, essential for a slave society. This is the work that I'm now trying to do, with a different focus from my earlier work on white imperial identities. The turn to trade, the economy, the plantation, the state, the law, and reproduction places racialized ideologies fully in their material contexts. I'm utilizing the thinking of revisionist Marxists alongside feminists and Black radicals to grasp the interconnections of the material and the discursive, how together racism and capitalism can function as a system, though always with conflict and contradiction. But unlike Humpty Dumpty, everything does not fall down at one go. So when thinking about how Victorianists might talk in these years about race, I would recommend a return to capitalism, the economy, and the state, while never losing all that we have learned from the cultural turn. Is racial capitalism a useful term for understanding the 19th century? How might it be characterized in the 1830s, the 1860s, or the 1890s? Thank you.
Thank you very much. Let's turn immediately to our next presenter, Sarah Winter.
Thanks very much. I'm very happy to be on this panel with Catherine Hall, and I want to also thank Sukanya and Lauren and Kiana and others who have organized this event. I'm going to drop a list of sources into the chat so that you can find some of the critical readings that I refer to.
I'm not sure if those will be available to the people, but if they're not, we'll definitely.
Okay, thank you, Jonah.
We'll put it up on our website as well.
Okay.
After the today.
Perfect. So I don't see myself. Do others see me in the video?
Yes, you look great.
Okay, thank you. All right, I'll just make sure. Okay, I'll start my talk. Both John Anderson, an American fugitive who became a refugee from slavery in Canada, and George William Gordon, the son of a Scottish lawyer and an enslaved woman who served as a justice of the peace and member of the Jamaica Assembly, became the subjects of fraught political contests over the international jurisdiction of the English courts and legal accountability for imperial misgovernment between 1861 and 1870. Drawing on Shauna Dorset's and Sean McVeigh's critical theory of jurisdiction, which provides, in their words, a method for how to think about making law work differently and how to take responsibility for the form and force of our law. This paper studies potential decolonial jurisdictions that emerged and receded in Anderson's and Gordon's cases and influenced their divergent fates. Anderson retained his liberty as a British subject, avoiding extradition to the United States for stabbing a slave catcher during his flight, while under the personal supervision of Edward Eyre, the governor of Jamaica, Gordon was arrested and executed under martial law during the Morant Bay Rebellion of 1865. In both cases, citizen activists and lawyers pursued jurisdictionally based strategies that succeeded for Anderson, and in seeking legal accountability for his execution in English courts, spectacularly failed for Gordon. In comparing the two cases, an historical narrative about Black legal activism and citizenship emerges that dissenters liberal constitutionalism and metropolitan humanitarianism. I argue that Gordon, in his role as a magistrate, devised an equitable decolonial jurisdictional practice to uphold the rights and citizenship of Jamaica's Black peasants, and to correct the systemic racism of the post-emancipation legal system. Anderson's case also suggests an historical model for more effective decolonial legal jurisdictions and remedies with a transnational scope that were precursors for legal and political activism on behalf of detained refugees today. I'm interested specifically in the international habeas corpus jurisdiction activated by Victorian abolitionists to prevent Anderson's extradition. Dorset and McVeigh define jurisdiction as the practice of pronouncing the law that both formally declares the existence of the law and the authority to speak in the name of the law. Thereby, this practice opens up a domain of thought or a jurisprudence, concerned both with how to live with law and how to create and engage in lawful relations. So these are quotations from their book. Jurisdiction, they argue, is both itself a practice and conduct of law, and a distinct form of critical engagement with law. A key element of their method for my purposes lies in their emphasis that, quote, thinking about jurisdictional form in terms of a practical activity allows for the diminution of sovereign-centered accounts of law, focused primarily on the state. The cases I present today are part of a book in progress that charts the legal history and narrative conventions that have emerged from more than 2 centuries of citizen activism by and on behalf of enslaved people, abused wives, refugees, members of religious minorities, workers incarcerated by their employers, and enemy detainees. These activists put pressure on the courts and both metropolitan and colonial governments by means of the common law procedure of habeas corpus, an urgent due process remedy that enables the court to scrutinize the legality of a person's detention. I date this legal tactic to a series of late 18th century anti-slavery cases before the Court of King's Bench in London, initiated by radical political activist Granville Sharp between 1767 and 1772, that also began to articulate the rise of the rights of enslaved people as universal human rights. The most influential of these cases, which Catherine already discussed, is the 1772 ex parte Somerset decision on a writ of habeas corpus. And it concerned James Somerset. And I won't go over the details again because Catherine already explained that he had escaped and he was kidnapped and he was meant to be deported back to Jamaica. William Murray, Lord Mansfield, Chief Justice of King's Bench, granted a writ of habeas corpus to remove Somerset from detention on board a ship where he was being held on Stuart's orders. So high an act of dominion was never in use here. No master ever was allowed here to take a slave by force to be sold abroad, declared Mansfield in his famous ruling on the case. Therefore, the man must be discharged. I show that this litigation inaugurated a strategy to employ habeas corpus in a kind of collective litigation or class action, which attempted to make James Somerset into a representative of all enslaved people in England. This strategy has persisted to the present. For example, in January 2017, ACLU lawyers combined habeas corpus with a class action to successfully petition a US federal court for an injunction to release travelers and refugees detained at airports under the Trump administration's travel ban against majority Muslim countries. Sharp and the lawyers he employed also presented the kidnapping, deportation, and punishment of fugitives as illegal personal assaults. The combination of an assault charge with the procedure of habeas corpus enabled the Somerset litigation to indict and publicly expose enslavement as a violation of personal rights within England. At the same time, the writ of habeas corpus also became an effective, if limited, remedy for the unlawful perpetual detention authorized by colonial legal titles in chattel human property. Voicing a similar attack on slave property, Atoba Cugoano, in his text of 1787, condemned what he called European merchandising of enslaved Africans. And he made this condemnation in the most radical anti-imperialist and anti-racist terms as theft rather than legal ownership. I argue that in seeking a remedy for such systemic criminal acts, these early activists found in habeas corpus a means to evade the imperatives of property or dominion normally privileged by the common law. My intent here is not to celebrate habeas corpus, since the legal process could fail for many reasons, including lack of funds to initiate a suit. Commenting on the Somerset decision in his authoritative history of habeas corpus in the British Empire, Paul D. Halliday emphasizes that, quote, by issuing the writ, King's Bench fitfully made a new jurisdiction for itself. By its judgment, it began very slightly to kill off the jurisdiction of slaveholders over their slaves, just as it had always contained the jurisdiction of all others who held the bodies of the king's subjects. Halliday shows how 17th and early 18th century habeas jurisprudence extended the authority of King's Bench into all the territories and corporations and jurisdictions established by the English sovereign. By the end of the 18th century, he argues, the law concerned with habeas corpus thus marked a huge zone of inclusion, the farthest reaches of a singular subject status, even while other aspects of English law remained immobile. The reputation of habeas corpus as a bastion of the liberty of Englishmen, however, also aligned with British justifications of their expansion of the common law into colonial territories, creating new jurisdictions and displacing previous legal institutions and indigenous ways of law, so that habeas corpus jurisprudence was also at issue frequently during colonial rebellions. Halliday recounts that after the 1790s and through the 19th century, parliamentary suspensions of the statutory writ created by the Habeas Corpus Act of 1679 enabled detention of political dissidents without court scrutiny. Suspensions of habeas corpus became a means of controlling political dissent within Britain, as well as a conspicuous legal instrument of imperial rule, as colonial legislatures adopted their own versions of the habeas corpus statute. Periods of martial law imposed to quell colonial rebellions were often followed by legislated indemnity for violence committed by military enforcers, as indeed happened after Eyre's imposition of martial law in Jamaica. Jamaica's statute permitting the governor to declare martial law had been passed in 1681 to enable repression of slave rebellions. When Sharp's failure in the Zong case in 1783 happened, abolitionist legalism seemed an inadequate approach, and the international abolitionist political movement was launched in the late 1780s. Thus, this early legalism was eventually submerged within political debates and in British public consciousness by the humanitarian narrative of philanthropic rescue. But at times, the habeas corpus jurisdiction and its varied narrative forms, including the sentimental and the Gothic, resurfaced in legal trials and literary fictions through the 19th century, while the civilizing humanitarian project of abolitionism became official British imperial policy and a pretext for the colonization of Africa in the later 19th century. So now I'll briefly recount John Anderson's case as one of the moments when the early abolitionist legal strategy reemerged. By the mid-19th century, Canada and Canada West in particular had become a refuge for many Black Americans who had escaped from enslavement in the United States. In 1853, one such fugitive, Jack Burroughs, set out from Missouri heading to Canada. But during his flight, he stabbed a Missouri planter, Seneca Diggs, who was attempting to recapture him in order to collect a reward for his return. Burroughs escaped, but Diggs later died. With the assistance of abolitionists on his passage through Illinois and Michigan, Burroughs made it to Canada, where he lived under the name John Anderson, until he was arrested in April 1860 for Diggs's murder and jailed in Brantford, Ontario. The arrest was followed by a formal request by Lewis Cass, the United States Secretary of State, to Lord Lyons, the British ambassador in Washington, for Anderson's extradition to the US to be tried for murder, a crime covered under Article 10 of the Webster-Ashburton Treaty of 1842. At the time of the treaty's signing, however, British abolitionists have been able to article not be used to extradite fugitives from slavery who were effectively refugees for acts done to escape bondage. Canadian abolitionist lawyers made multiple attempts to obtain Anderson's release on the basis that he was defending himself from re-enslavement and abuse, while their counterparts in Britain pressured the government to instruct Canada's Governor General, Sir Edmund Head, not to approve any order to extradite Anderson. Anderson's Canadian lawyer, Samuel B. Freeman, petitioned for and was granted a writ of habeas corpus for Anderson from the Court of Queen's Bench in Toronto. At the hearing on November 24th, 1860, Freeman argued that in seeking liberty, Anderson had a right to kill his pursuer, and that the law under which Digges had acted was a slave law, and Canada did not have slavery. Therefore, Digges must be considered a trespasser and Anderson freed. However, the court determined that although Anderson's act could not be considered murder under Canadian law, the provisions of the extradition treaty should still be followed strictly, and therefore Anderson could be extradited pursuant to the Governor General's order. When the Canadian Anti-Slavery Society leadership informed their counterparts in Britain of this latest setback in Anderson's case in January 1861, the secretary of the British and Foreign Anti-Slavery Society, Louis Shamarozov, a Polish-born journalist and novelist, determined to seek a higher jurisdiction to prevent Anderson's extradition. He collaborated with a group of lawyers to petition the Court of Queen's Bench at Westminster for a writ of habeas corpus to be issued to the Sheriff of York and the keeper of the Toronto jail to bring Anderson out of Canada before the court in London for a hearing on the legality of his detention. Speaking for the court, Chief Justice Sir Alexander Cockburn ruled on January 15th, 1861, that despite any inconveniences that may result from the exercise of such a jurisdiction, the writ ought to issue, and nothing short of a legislative enactment expressly depriving us of this jurisdiction would warrant us in omitting to carry it into effect when called upon to do so in protection of personal liberty. Although some members of Parliament expressed concern that the writ would not arrive in time to prevent Anderson's extradition, in the event there was prior movement on the Canadian side to resolve the issue. Anderson's lawyer Freeman petitioned another Canadian court, Common Pleas, for another writ of habeas corpus for Anderson, on the basis that there had been flaws in the American legal process that had produced the arrest warrant. The judge agreed and Anderson was discharged. So while the writ had issued to remove the prisoner from detention across the seas, it had no force by the time it arrived at its destination. As if following the Chief Justice's instructions, in May 1862, Parliament passed an updated Habeas Corpus Act, which ended the international jurisdiction of Queen's Bench in London to send a writ of habeas corpus across imperial borders into any colony or foreign dominion where courts already existed that could issue the writ and ensure its execution. As a result, the imperial writ was no longer available when the same British abolitionists who had mobilized for Anderson learned about the extreme violence inflicted on Eyre's political opponents and on hundreds of Jamaica's Black peasants under martial law in October 1865. The events preceding and following the protest of Black Jamaican peasants and small landholders and their attack on the Morant Bay Courthouse on October 11, 1865, can be described as a political dispute which turned violent over the definition and functions of lawful jurisdictions, both in Jamaica and in British imperial governance. A central element of Black Jamaicans' grievances in the decades after emancipation in 1838 included their unjust treatment by a judicial system presided over by white magistrates, who were often plantation owners. Once Eyre's actions in authorizing the violent reprisals became known in England, a major focus of Eyre's critics correspondingly became jurisdictional. In a statement published in the Liberal Daily News in July 66, Mill explained that the Jamaica Committee's private prosecution of Eyre was meant to test, quote, the jurisdiction of courts of martial law, to have it determined by authority whether the law which these courts assume to administer is really law at all, or sanguinary license which the law will repress and punish. Mill also described Gordon as a political prisoner, precisely the kind of person whose rights and body activists across generations have sought to protect by means of habeas corpus. But Gordon's activities as a magistrate align him with the more radical strand of citizen activist I study, rather than with mid-Victorian liberals' political concern over the constitutionality of martial law. Therefore, I want to highlight the jurisdictional struggles that occurred in Jamaica before the resistance at Morant Bay led to Eyre's reprisals and targeting of Gordon, I also follow post-colonial international law scholar Sundya Pahuja's approach to critically redescribe post-colonial legal disputes as situated with what she calls ongoing encounters between rival jurisdictions deriving from colonization. She explains that, to quote, critical redescription is an attempt to redefine through narrative a world we take for granted, inviting it to be seen differently as a mode of political engagement. Focusing on India and Australia, Pahuja gives the example of the international development narrative, according to which indigenous lands can be allocated by the state for mining projects as long as the inhabitants are compensated financially. She contends that, quote, the imperative to conduct the meeting between tradition and modernity lawfully or legally means to accord one tradition the process rights decided by another tradition and violently to enforce them if resistance persists after due process. Instead, she argues, by refusing the absolution afforded by the international development narrative, which implies that such dispossessions are inevitable, and viewing sovereignty as a practice rather than a fact, she suggests we can begin, quote, to ask questions about how the state is actualized and how rival forms and accounts about political authority and ways of belonging to law are enacted and performed over the same people and the same places at the same time. So following Pahuja's approach, the dispute over land claims on October 9th that was said to have triggered the protests and attack on the Morant Bay courthouse on October 11th becomes more significant. Louis Shamarovsov published in the Anti-Slavery Society Circular a letter dated October 28, 1865, from an unnamed informant described as a gentleman of Jamaica and an authority there, who reported that the land in question was an abandoned plantation claimed by W.M. Anderson, the immigration agent of Jamaica. The informant explains that, quote, his title is disputed by the settlers of Stony Gut, and they have been for many years under the impression that no one had a right to it but themselves. This account suggests that the Black settlers collectively exercised a rival jurisdiction to inhabit abandoned land and claim ownership over it by cultivating it and paying taxes on it. In doing so, they were cast as a form of decolonial reparation, the purported natural right to occupation that had been asserted by European empires since the 16th century and justified by John Locke's theory of natural title in his second treatise on government of 1689. According to this same informant, during the violence under martial law, the settlement of Stony Gut was entirely destroyed. Through critical redescription, we can identify Eyre's military reprisals as collective expulsions. In his tenure as a magistrate and legislator, George William Gordon also sought to reform Jamaica's post-emancipation legal system to render it more just and equitable by protecting impoverished Black and South Asian Jamaicans' rights as citizens. A clash with the outgoing Governor Darling in February 1863 signals Gordon's innovations on local Jamaican jurisdictions. As a visiting justice at the Morant Bay jail, Gordon left instructions for the keeper of the jail to commit a sick prisoner to the hospital, to empty the cesspool, which had not been cleaned for 5 years, to keep more accurate records and logs on the prisoners committed, and to feed the prisoners beef once a week. Gordon's instructions, like the writ of habeas corpus, can be theorized as what Dorset and McVeigh call a technology of jurisdiction. They define that as a technique that encompasses the idea of devices and organizational strategies, including many kinds of legal writing and formulas for correct procedure. We can grasp the potential remedial force for past rights violations under slavery of Gordon's jurisdictional practice in the response his routine instructions elicited. Governor Darling's secretary sent Gordon a letter reprimanding him for exceeding his authority and warning him he would be removed from his office as a justice of the peace. While Darling did not act on this threat, Gordon became the target of a similar reprimand by Eyre in March 1863. Once again, on a visit to the Morant Bay jail, Gordon discovered that an impoverished and ill man had been lodged in the latrine. Gordon subsequently filed a complaint about the deplorable conditions in the Morant Bay prison that called attention to the failed oversight of a local Anglican rector who had sent the man to the jail because he claimed there was no poorhouse in the parish. In retaliation, Eyre ordered Gordon to be dismissed as a member of the St. Thomas Vestry, which administered local government, and from his judicial office, despite an investigation proving that Gordon's complaint had been justified. Eyre's actions made clear that Gordon's judicial office did not, in fact, entitle him, specifically as a man of color, to criticize or give instructions to any white officials of the Anglican Church, courts, or colonial government. These dismissals reveal that in fulfilling his ordinary functions as a magistrate, Gordon was in fact inaugurating a rival equitable jurisdiction that set aside whiteness as a guarantor of legal and political authority and social and economic privilege in Jamaica. Eyre's removal of Gordon from the magistracy was later cited in London newspapers as a justification for Eyre's actions in arresting him in Kingston. Much as had been planned for Somerset, Gordon's arrest was followed by removing him on a ship to the parish where martial law was enforced so that he could be tried under martial law, under court martial. In the same issue of the Anti-Slavery Society circular, in which he had provided the corrective account of the alleged insurrection at Morant Bay, Shamarovsov quoted a passage from the Times justifying Eyre's reprisals, which read, "Gordon was a magistrate, but had been dismissed by the governor for seditious harangues." Shamarovsov refuted this statement, writing, "Mr. Gordon was suspended for no such reason, but for defending the case of a poor Black man, the victim of oppression." This rebuttal shows that Shamarovsov was aware of the Jamaican legal system's bias against Black Jamaicans. In this light, the British and Canadian abolitionists' earlier intervention on Anderson's behalf appears not simply as a humanitarian campaign, but also as an effort to conjure up a rival remedial jurisdiction within the empire. Within this jurisdiction, Anderson's release elevated his personal right to asylum from slavery above the requirements of an extradition treaty. It set a legal precedent that threatened to override the prerogatives of British foreign policy, suggesting why government quickly reasserted parliamentary sovereignty to abolish it. So to conclude, Anderson and Gordon could both be defended by British abolitionists because they were viewed as Black victims of oppression, unlike the leader of the protests at Morant Bay, Paul Bogle, who was also killed during Eyre's reprisals, but whose individual fate was not contested by the anti-Eyre forces. However, when we view both of these men, as well as the Black settlers of Stony Gut, as initiators of rival jurisdictions, we can also critically redescribe Anderson's flight from slavery as the pivotal event that activated the abolitionists' transatlantic jurisdictional tactics, giving rise to a short-lived rival imperial human rights jurisdiction. Victorianists might talk about race and structural racism then, from the critical jurisdictional perspective suggested by these two historical cases. That is, from the perspective of racialized subjects who practice legal equity and social justice, and in doing so actualize their citizenship politically and created jurisdictional models and legal tactics for the future. I'm not suggesting that we all need to acquire the technical expertise to study jurisdictions, but I hope to have provided you with an approach for provincializing European forms of sovereignty as what Pahuja calls European laws of colonial encounter. Here are a few heuristics, some of which will be very familiar to many of you. When we talk about race and empire, we should talk about resistance. When talking about sovereign violence and metropolitan law, we can begin by talking about rival, indigenous, and decolonial global South jurisdictions. Talking about rights violations, both historical and ongoing, would then entail locating and articulating demands for remedies and reparations in order to take responsibility as scholars for the wrongs of colonialism. The end.
Thank you so much. It is wonderful to be present for the transition from the hypothetical how Victorians might talk about race to the actual moment of Victorians did just talk a lot about race. Victorianists did just talk about race. So I'm would like to invite everyone in the audience to please share questions, comments, responses through the Q&A box. And I will give you a second to sort of figure out where you are and start perhaps typing those in. I also, let me take a sip of water as well. I guess let me ask maybe an opening question to kind of try to respond a little bit about, especially from my limited background in legal history, and to connect to the central kind of literary text of Catherine's talk. I was obviously very interested in Catherine's history of Long's text as one of the key theorizations of racial difference. And I wanted to ask you, Sarah, is there any kind of equivalent popular vernacular work that's being done to translate these specific legal practices, like rather maybe not generally available, into some more popular narrative forms?
Particularly now, or
at the time, sorry, in the 19th
at the time,
century.
yeah. So what happens is, in part, is that there's some biographies and commentary on the abolitionist movement by Thomas Clarkson, and Sharp's biographer, whose name was Prince Hoare, H-O-A-R-E, do sort of mobilize these habeas corpus cases as into a kind of narrative, which has these recurring features. It has very recognizable characters. There's a figure often called, whom I call the chastened magistrate, which is Lord Mansfield, the judge who realizes that he made a series of errors in allowing slavery by law, and that he's convinced to turn things around. Some of you may have seen the movie Belle that came out a few years ago, and that's a version of that figure. It also stars the prisoner, those who intervene to help the prisoner, and the writ itself becomes a major character. And in this narrative form, it takes place on a ship. There's a sentimental scene of the slave waiting for the writ to arrive. When the writ arrives, the slave is, the enslaved person is overjoyed and is liberated. So that sentimental narrative gets unleashed. There's also versions that are more Gothic, and one of the novels I discuss in my book is Caleb Williams, which I think incorporates this narrative that the abolitionists devised, but turns it into a darker, more in a political sort of scenario. And in the two versions of the end of Caleb Williams, if any of you have read it, one Caleb is liberated, but in the other he remains in jail. So it takes a Gothic turn. And there are a number of novels that kind of replay this over the 19th century. I won't list them all, but that gives you an idea of what this looks like.
And are there, the Q&A is still maybe a little silent, so let me just even a little more encourage everyone to type in your responses and comments, and there's such a distinguished crowd in the audience. I would love to hear more. Oh, great, okay. I would like to relay a question from Amy Woodson Bolton, who'd like to ask Professor Hall if you are considering environmental historical approaches in your approach to culture, economies, and material histories in your study of racial capitalism.
Yes, I am, but I wouldn't say it's a central question, because there is so much to deal with in disentangling all Long's work. I mean, over 3 volumes, he writes about everything. And so that's what I'm trying to deal with. But he is very interesting, for example, on mahogany. And was aware of the destruction of mahogany And there are now people working on the mahogany trade in between Britain and Jamaica. It's completely fascinating. The discovery of mahogany was incredibly important, and it was a very, very important product for Jamaica in the early 18th century. But basically, they cut all the trees down, and for example, Chippendale's furniture, which is some of the most beautiful, wonderful craftsmanship of 18th century England, can be seen in many wonderful country houses to this day. That mahogany came from Jamaica. So Long realized that the destruction of mahogany was a serious problem. And he realized also that to develop an island as a monoculture was a very destructive thing to do, that he makes strong arguments for a more diverse economy, which of course did not suit the metropole at all, because they wanted cheap sugar and the control of sugar as that was the purpose of Jamaica as far as they were concerned. So there are these issues, and I mean, another whole issue would be the mosquito and the importance of the mosquito in this period, and Long pays quite a lot of attention to that. So in that sense, I'm touching on those issues, but I could not pretend that it's at the heart of the narrative I'm going to be producing. That would be, yeah, I couldn't pretend that.
And I wouldn't want you to. Ryan Fong has asked, I will just say that both talks ended very helpfully for us with some suggestions about tools to use moving forward in a particularly prospective way. Ryan Fong wants to ask about how we might look backwards. So he's mentioning the ways that each talk engages with other intellectual and jurisdictional frames, and asks, can you say a little bit more about what has prevented Victorian studies from engaging with these traditions, specifically racial capitalism in Catherine's talk and indigenous sovereignty in Sarah's talk? What has prevented Victorian studies from engaging with these traditions, and what methodological and epistemological shifts would need to take place if we engage and even center these frames? And he gives the example, what happens to Victorian studies when we center a critical genealogy like Dubois, C.R. James, Cedric Robinson, Gerald Horne, and Robin Kelly, for instance. So either might respond.
Well, I suppose what I was, I mean, if I can just begin, what I was, I mean, I did remind everyone at the beginning that I haven't been working on the 19th century for quite some time. But when I was, the crucial questions were those of the cultural historian. And so the work that's, what happened, obviously historiography hasn't developed in exactly the same way in Britain as it has in the US. But certainly the shift into cultural history in the wake of the dominance in the 1960s and early 1970s of questions about class as central through, obviously, the Marxist historians. The shift from that to cultural history, which was, of course, partly mediated by Edward Thompson's The Making of the English Working Class, just produced a different kind of focus and effectively killed economic history, which went into an incredibly boring version in the 70s, which social and political historians were more or less excluded from. Economic history departments more or less disappeared in Britain. And for example, the debate over the standard of living, which just became so arcane and unrooted in people's lives. So the cultural turn had a huge impact, and the effect of that was, for a very long period, very little attention to the economy amongst certainly British Victorianists. And I think that would, I mean, it's certainly true of most of the Victorian scholars from the US that I know from that period. So I think the turn back to the economy, and the law is obviously a different, I mean, I don't mean there haven't always been economic historians and there haven't always been legal historians, but what are the key questions for historians now? I think capitalism has come back into the frame in a way that it simply wasn't for a long time. I mean, it was there for the Marxist historians, and now it's come back both through new forms of revisionist Marxism, but also, of course, through Black radicalism and that intersection with Marxism. So I think we've just got a different set of questions which come out of not just the historiographical shifts, but out of the shifts in politics that 2007 has produced in the US. I know all these courses now being taught on the history of capitalism. Nobody was teaching the history of capitalism before. So it's a really important set of shifts which open up different questions and the need for a different kind of work. But that doesn't mean that all the other kinds of work aren't still absolutely vitally important. It's just, you know, these are some of the different strands that we're thinking about in the current moment.
Sarah, did you want to respond?
Yeah, sure. So yeah, I'm looking at the question. One of the aspects is methodological and epistemological shifts that would need to take place if we center a frame such as Indigenous sovereignty. And I guess one of the shifts would be that sovereignty has to be more of a gradient rather than a kind of monolithic concept. And therefore, you know, if alternative jurisdictions exist, or if they, you know, attempt to come into being in the context of a situation where we tend to think that the state is dominant, or that the colonial governor, for example, is dominant, then in order to center some of these either indigenous or resistant efforts, we have to look more at what's happening from the ground up. And the epistemological shift would perhaps be just to sort of not assume that the violence, not assume that the sovereignty in play is totalizing. So, I mean, the way I've done this is to look at habeas, because, you know, and the other way to do this is to look at these long traditions of tactics. I've talked about it as citizen activism, and the fact that if you center, you know, an indigenous kind of sovereignty or a resistant jurisdiction, then you start really looking at what makes these different forms, these resistant forms, work. And then you kind of have to ask, well, who are these people who are trying to engage in the resistance? And then I guess epistemologically, it just means that the dominant voices, you know, move to the periphery, and the less dominant voices come forward. And then you begin to understand that there are ways to tell these stories differently. To situate these historical narratives differently. That would be, I mean, and obviously interdisciplinary scholarship looking at what's going on in post-colonial theory and Indigenous studies. I think that's what Ryan is already doing.
Yes, I mean, we're so grateful to the work of all of our audience members, as well as, of course, our incredibly distinguished panelists. Let me turn to another question for Sarah from Nathan Hensley, which concerns the rival jurisdictions. And I'm just going to read this directly. In an asymmetrical context where the monopoly on violence does not belong to the polities proposing these rival orders of legality, he is curious in what sense these schemes have concrete purchase, especially when, as many other massacres of the period seem to suggest, any legal protection could be supervened by governors or generals in the field and then retrospectively justified. So asking, how does the monopoly on force relate to the question of rival jurisdictions?
Yeah, I mean, the colonial scene, you perhaps know the book by Nasser Hussain, that looks at India, and he shows very well that it's called the jurisprudence of emergency. He shows very well that whenever these rival jurisdictions do emerge, or there is an attempt to push back on the colonial government's powers, it's very, very difficult to make any progress. So that the area does seem to be sealed off. And this is the issue, I guess, of temporality. One way to think about this that I've figured out by studying habeas is the question of temporality. And literally these efforts either succeed or fail if the legal process unfolds in a timely manner and the writ arrives. If the writ doesn't arrive on the ship, Somerset is not removed and he gets shipped off to Jamaica. And so what's happened in the colonial setting and in Morant Bay, as I mentioned, is that there is no way to access the writ if the governor has moved, the prisoner into the sphere of martial law and court martials. Now, the one thing I would say just briefly is that there are two kinds of writ of habeas corpus. There's the common law writ, which is the older one. And then there's the statutory writ, which is created by the Habeas Corpus Act of 1679. And as Halliday explains, that's the one that gets used quite often in the colonies when colonial governors declare martial law and they suspend habeas corpus. So the way that the thing that I ask is, if there are courts open, is it possible that anybody could get the common law writ despite the suspension of the statutory writ? And so I guess the sort of puzzle that I always try to untangle is, what is tactically possible within these fields where it seems as if the sovereign violence is sealing off all recourse that could still happen either in a timely manner, or in any other way to kind of make some effort to sort of break open the monopoly of violence. Now, in a historical sense, it's very difficult. In a theoretical sense, I think we can look again and not assume that that sovereignty is this this force that always is in control, and that we can kind of set it aside for a second to see whether there are ways of intervening. Anyway, I'll stop there. It requires a lot of sort of re-theorizing and specific research on cases.
Yes, so I appreciate very much the tension in all of the conversation we're having between great specificity and very broad kind of calls to action. And our next question sort of speaks to that a bit. The questioner is asking, what seminal texts would you recommend introducing to sophomore literature students I believe to kind of capture some of the, I don't think rival, but tension, two tensions that we've identified in these talks between a sort of a broad call to arms to reinterpret and reimagine the scope of the work that we do, and the ways in which we do it, as well as a retained attention to great historical specificity in how we look at particular moments within a changed way of talking about race. So I think this person would like to ask a sort of practical pedagogical question of sort of where do we begin, maybe? With what work might we enter this question? It's very difficult question to answer in some ways.
So you're talking about the question on the Britlit survey? Yeah.
Yes.
So, I mean, there are radical Black pamphleteers in the early 19th century. One of them is named Robert Wedderburn, if you can get a hold of his pamphlets. And then there's Mary Prince's narrative, which is a very complex text, but it does have a really great edition from Penguin, edited by Sarah Saleh. And that would definitely enable your students to get a sense of the contestation surrounding slavery and the difficulty for a person of color to appear in the public sphere, and all the complex issues that go around making those narratives available.
I suppose what I just want to say in response to that is that, you know, that's possible in the 19th century. It's not possible in the 18th century. It doesn't happen. I mean, there's Equiano's text in the 1790s, Sancho Cuguano, Phyllis Wheatley. I mean, there are new voices in the late 1780s and 1790s, but before that, there aren't any.
Yeah.
And that's because of very different societies, very different situations from the one that Sarah's been describing. I mean, in Jamaica in the 18th century, there are no alternative forms of jurisdiction. There are slave courts, of which unfortunately we have no records. I mean, if you look somewhere like the Cape, it's different because you've got the Dutch legal system and the British legal system, and that opens up opportunities. But Jamaica was it was a garrison state where martial law was very frequently in operation, and where, of course, sovereignty was never complete. It couldn't possibly be, but it couldn't be expressed in the forms that become possible in a later period. Or I mean, what I mean is the challenges couldn't be expressed. The challenges are expressed through running away and rebellion and, you know, refusing to work on the plantations, all those kinds of things. But there couldn't, I mean, a legal challenge was completely impossible in Jamaica in this period, in the period that I'm working on.
Have you looked at the Maroons at all?
Yeah, but of course, they are operating. I mean, the treaty is a very, very interesting document, and the way in which the Maroons are able to survive as a separate community with only limited responsibilities to the government, that is significant. And they stand as a very significant alternative to slave society. But they don't, you know, they're not using, they're making it possible for the whole system to operate because of the ways in which they've conducted a treaty which requires them to return runaways and fight rebels.
Yeah. I think that there are really, it's true that the 19th century produces a lot of these cases, and as I said, they're, you know, I sort of date them to the late 18th century, these uses of the writ of habeas corpus. But once you look in you know, you can find these quite extraordinary cases where individual petitioners manage to use the legal system and the complexities of jurisdiction. The writ for the son of Sojourner Truth, which she, you know, the suit that she initiated in, it was, I think, 1828 to regain her son, who, you know, the writ itself has just been discovered in the New York State Archives. And there it was because the state of New York had created a sort of gradual emancipation system, and her son was born, had been born after the date at which anybody born would be free. And nevertheless, her enslaver had sold him, and he was sent out down to the South. And she was able to recover him through a habeas corpus suit that took place in New York State under New York State law, and was able to get damages as well. So this is the type of layered jurisdictions, as Catherine suggests. You have to be in a field where these different possibilities exist.
But it's also, of course, the archives vary a lot. So that, you know, the kind of the legal cases that Jennifer Morgan's been able to work on in Virginia and other people in a much earlier period are really, really interesting, where there are lots of women challenging the claims that slave owners are making. But there's simply no, unfortunately, in Jamaica, there's no equivalent to those records. The Wedderburn text that you mentioned is really a fascinating one.
Yeah.
And has been written about very interestingly, as well as his own text, which is indeed fascinating. He was a black radical, but unfortunately he stopped being a radical in his later years. But anyway, he had a very dramatic radical moment.
Can I ask a quick follow-up question to that for Catherine? You said, I think it was in passing, you mentioned, unless I misheard you, abortion as a form of resistance. You mentioned it in a sequence with running away. If I'm, can you say two more words about that? I mean, that seemed, in terms of like evidences of agency, it seemed like particularly, and of things that aren't there, it seemed like a particularly poignant one. If you have a few more words to say on that, that'd be fascinating to hear.
Well, there's been really interesting work done recently on runaways in the UK, and a new database actually recording the cases from the newspapers. And there are records of that in Jamaica as well. So running away and being quite a number, I mean, we think quite a lot of Africans in London particularly were able, unlike Somerset, who was caught, they were able to live with different names, as Sarah's other case, Anderson, was able to do in Canada. That was happening on quite some scale.
Yeah.
But the slave owners were very, very active in trying to catch people that they regarded as their property too. So the newspaper reports are a really, really excellent source on that, both to find out who had escaped and who was trying to recapture them.
Yeah, I think that the other thing we could say is that thinking about Edward Long, one of the things that you notice is that on the Somerset decision, if you look into the historical discussion of it, it's often stated that it didn't actually free the slaves in England, and certainly didn't free them outside. But what happens, this is something that Douglas Lorimer showed, is that enslaved people and people of color in England believed that they were liberated by it, and therefore they ran away more frequently to sort of follow up on what Catherine's saying. So that decisions that seem to, or that we're told actually don't do certain things, they have effects and they're interpreted by people whom they impact to mean things that then unleashes their activities, their response. So that's another sort of element of sort of pulling back from sovereign exertions of power and seeing the how different kinds of legal decisions or other kinds of political acts are interpreted by those they impact.
No, that's absolutely right, and that's why I describe the period 1772 as a new conjuncture, because it opens up different kinds of possibilities. But of course, it also unleashes new forms of pro-slavery argument.
Exactly.
Because Long writes the history in the way that he writes it, specifically because of, I mean, first of all, he responds to Mansfield in his ghastly pamphlet, Long's ghastly pamphlet, which is a piece of polemic. But then he decides he's got to write in a much more substantial way and defend slavery. And the reason is that the law, what the slave owners think is that they can no longer rely on the law. They've been able to rely on the law up to that moment. And indeed, sometimes they can afterwards, because as Sarah's just said, there are cases afterwards which go both ways. So the law is not consistent at all. And what the slave owners wanted was a law in Parliament that was in favor of slavery in England, but they were totally unsuccessful in the claim to make that law.
Yeah.
So it opens up a whole set of different kinds of, a different politics of race in the period after 1772, basically.
And the other thing I could mention in addition to what you've said, Catherine, is that if you're looking in the archives or you're looking at these documents and you're trying to figure out what legal decisions and political events mean, some of the people, such as Long, who, their response to the Somerset decision and the vociferous way in which they attempted to refute it and call it a mistake indicates that it had a force that wouldn't be strictly, sort of encompassed by saying that legally speaking, enslaved people weren't liberated, because a lot of people who were interested in maintaining slave ownership felt very threatened by it. So that's another, and exactly as you pointed out.
But it's also crucial in the development of Long's thinking, because he turns to the body because the law is no longer enough.
Mm-hmm.
So, I mean, that is a very, very significant change in terms of legitimations of racial thinking. They didn't need to rely on the body until the law would no longer do that work for them.
I'm sorry to say that we are at the end of our time for this panel, and I think Professor Hall has left us on that with that turn to the body on an amazingly fruitful pausing and point to pause, reflect, and move on to our next panel. So I would like to thank very much the presenters for their contributions, and to the audience for your attention and questions. And thank you so much.